Musk has inserted himself into the sale of InfoWars to The Onion. I mean, can we just take a minute here? If the year was 2019 and I said that sentence, you'd think that I needed to see a doctor. But hey, it's not 2019, it's 2024. And in this world, Elon Musk owns Twitter, even though it's not called that, and Alex Jones no longer owns InfoWars, and The Onion is somehow buying intellectual property and fake supplements in bankruptcy auctions. Anyway, this limited objection was filed last week by the X Corp, trying to stop the sale of the X, also known by the whole world as Twitter accounts, of InfoWars, Banned Video, The War Room, and Alex Jones. Let's find out what this objection is arguing and how it will affect the overall sale of InfoWars to The Onion, and I'm not joking. I'm America's attorney. I've been a lawyer for over 23 years. I've helped over 20,000 people, and I still do that work. But I also hop on YouTube at least twice a week to break down current events for you. So right now, let's jump in. As you most likely already know, Alex Jones was sued by the families of the Sandy Hook shooting victims for defamation after the InfoWars founder spent years claiming that the shooting was a hoax. The families of the victims won 2 trials and were awarded a total of over $1.5 billion in judgments. Jones then predictably filed for bankruptcy, which led to the sale of InfoWars and everything beneath it, like studio equipment, a Teradyne armored truck, and the company's social media accounts. Very important detail for later. The satirical news site The Onion won the bid for InfoWars, and while this win is currently being contested, it is not the topic of this video. So why don't we get to what is? Now, as I mentioned earlier, X Corp filed a limited objection to the proposed sale, citing pursuant to the successful bidder notice, the sale motion, and to the extent applicable, the Jones IP sale motion, the trustee, the person now in charge of InfoWars property, now seeks to contravene X Corp's terms of service by improperly selling or otherwise transferring the X accounts, which neither Jones nor his bankruptcy estate own, to a third party. While X Corp takes no position as to the sale of any content posted on the X accounts, X Corp is the sole owner of the services being sold as part of the sale of the X accounts. So the company objected to the sale through 3 main arguments. Number 1, that the X's terms of service govern the X accounts up for sale. Number 2, that X owns the accounts in question. And number 3, the licenses to use the X accounts are non-assignable. So the first argument is that X and not the Jones entities own the X accounts. Well, not to start out the legal analysis with kind of a softball, but this is a no-brainer. The actual accounts on any digital platform are always owned by the platform. A platform is like a marketplace, and the marketplace is not owned by the buyers and sellers, but instead by the shopkeeper. So don't expect the bankruptcy trustee or the Onion to get turned around sideways or twisted around by this argument, because it really is common sense and well-settled law that the actual accounts, in fact, all the accounts that you yourself use online on every platform, they are all the property of the company who hosts them. But that is obviously not the real issue here. The real issue is the licenses. Because when you open an account with X, you become a licensee of their software. And as a quick refresher, a license is a legal permission granted by an authority or owner to do something that would otherwise be impossible or prohibited. It establishes terms and conditions, often requiring compliance with specific rules like, speed limits. Licenses can apply to activities like driving or intellectual property use or business operations. They may be revocable or renewable based on adherence to the original agreement. Your state owns your driver's license, even though it's your picture and not your governor's picture that they put on the license. But they can take it away. And X owns your X account, and they can take that away too. So this seems pretty straightforward. The Jones entities have been granted licenses, and the bankruptcy trustee asserts that the licenses have value and are therefore for sale. And while this might seem like a simple issue, imagine what problems would ensue if you tried to sell your driver's license. Well, it's personal to you, and to put it plainly, the Department of Motor Vehicles in your state would not permit that. But Twitter, isn't that different? And here's the real fight. Because the answer is, it depends. By the X terms of service, account licenses are not transferable by the licensee without the express permission of the platform. And X is saying, for now, that it does not consent to the license transfer. And why is that? Is it because Musk wants Alex Jones to enjoy his megaphone that he has on the loosely or unregulated X? Could it be that simple? Could it be that lame? Maybe. But a more likely reason is the way that the trustee of the bankruptcy estate framed the sale approval request with the court. Because basically it was inartfully drafted, and the request for approval talks about a sale of the accounts. And from a legal point of view, the most likely sticking point is that what X really wants is an order from the bankruptcy court that confirms that it is X that owns the accounts in question, and by extension, all the accounts on the platform, including yours. But maybe it's not so clean and nice as all that, because they also go to great lengths in their briefing to make clear that they do not consent to transfer of the licenses. So are we back to Musk being a bad man who wants Alex Jones to keep spewing hateful bullshit all over the platform? Maybe. But again, maybe not. Because if you put yourself in X's shoes, they want to be confirmed to be the owner of the accounts and in control of the licenses. Well, the best way, and perhaps the only way to get the attention of the bankruptcy trustee and the judge is to flex the muscle that you have, that you are in fact the owner of these accounts and that you have valid terms of service, and everyone else has to fall in line. It could be that simple, but there is a cliffhanger here. Because let's say that the trustee concedes that X owns the accounts, he agrees to resubmit his request to the court to sell the licenses. Well, what then if X doesn't consent? We can't yet know the answer to that question, but I can tell you this, it could create some drama. And that's a reason to lawyer up with me right now by subscribing to this channel. There's actually easy ways to do that on this platform, because the bankruptcy judge has some very real authority over the parties that appear before it. And I am sure that if X actually tries to jam up the sale of the Jones accounts, meaning the licenses, which it's not yet clear that that's what X is trying to do at this point, then we know that if that happens, we will cover that madness here on this channel, because the battleground will be whether the account services in question are truly personal or whether there's a legal and factual basis for the court to say that even without X's consent, if they never give it, that those licenses can be assigned. But that will be a decision for another day. For now. But what are your thoughts on X's filing? Well, what are your thoughts on the fact that your social media accounts aren't technically even yours? Drop your pro se opinion down below in the comments, which I own, and let me know what you think. And I'll be back soon with more videos, and you don't want to miss it, so I will see you then. And that everyone, and that